गुड आफ्टरनून फ्रेंड्स। मेरा इस वीडियो के ज़रिए कॉमन पब्लिक को जो उनका एप्रीहेंशन है कि अगर वो किसी भी ट्रायल कोर्ट का या लोअर कोर्ट का जहां उनका केस चल रहा है उसका ऑर्डर चैलेंज करेंगे तो वो जज उनसे नाराज होकर अल्टीमेटली उनके अगेंस्ट फैसला कर सकता है। ऐसी बात मैंने पिछले कई दिनों से सुन रहा हूँ। पर्टिकुलरली एक पढ़ा लिखा इंसान भी ऐसा सोचता है कि यार अगर मैं ऑर्डर चैलेंज करूंगा कोर्ट का तो ये मेरे अगेंस्ट जा सकता है। ऐसा नहीं है। पहले तो मैं आपको बता दूं कि दे हिंदुस्तान में, भारत में, इंडिया में हायरार्की ऑफ कोर्ट्स है। द फर्स्ट पॉइंट ऑफ contact फॉर ए कॉमन मैन with the law is the civil judge, junior division in case of a civil dispute, and judicial magistrate, either first class or second class, according to the offense. Then thereafter is the session court or the district judge, session judge court or the district court. Then is the high court. Then is the Supreme Court. So we have total four courts in hierarchy. And if the case is in some statutory provision, the original case is filed before the district judge or the session court. So then there are three courts, district and session court. Then is the high court, and then is the Supreme Court of India. And in some cases, the writ jurisdiction lies with the high court, original jurisdiction. Then in some high courts, there is intra-court appeal in the LPA, and then is the Supreme Court. And in some cases, there is original PIL or the writ can be filed under Article 32 before the Supreme Court. Similarly, there are other provisions where appeal lies either directly to the Supreme Court or the tribunal. There is an appellate tribunal. Recently, I came across a word from a litigant who is involved in a service matter dispute. He said, if I challenge the order in a LPA, the single judge might get annoyed. I tried to explain it. The judicial system and the presiding officer of the courts in India are such that they are trained in such a manner that they are not influenced by the thing that if their order is challenged to the higher courts, it might impact their mind or subconscious mind to decide against the litigant. This is not so in India. We advocates, legal professionals, judges are trained to decide according to the law. We advocates assist the court, judges decide the law according to their understanding. We assist the court according to our understanding. So as the experience goes up, one become wiser, so the horizon widens, so the decision maker making power also increase. So it is helpful. That is why even in the Supreme Court till last year in 2025, more than 80,000 cases have been filed. People are approaching to the higher courts, highest court. I am not saying the higher courts, highest court as well, against the orders of the other courts. The number of advocate and records who are entitled to file a petition in the Supreme Court are also increasing each year, only to address the need of the litigant, Indian litigants, particularly Indian litigants. Even recently, Supreme Court Chief Justice of India had said that when the common litigants approaches the court, he feels happy. That means even Supreme Court feels that the common litigant should approach the highest court of the land whenever he or she feels there something wrong has been committed or his or her right has been curtailed in an illegal or wrongful manner. So my limited purpose to come here is just to say filing of appeal revision against the order of a original or a first appellate court is a matter of right according to the statutory provision. That is why law provides for the filing of revision and appeals, because human judge is also a human, he can commit a error. That is why many decisions are made by the higher courts reversing the decision of the lower court. So there is no such thing in the Indian judicial system that the court will feel annoyed if their order is challenged to the higher court. I, by way of this video, I appeal to each and every person who feels to file an appeal or revision, but do not file only because he feels or he or she has apprehension that it might annoy the court or presiding officer. This is not so. Everyone has right to file the appeal or revision. So one should be free to use his or her right according to the law of the land. Thank you very much.